Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
I listened to my senior Martin Pebu. I listened to the other two. And I have no doubt at all that this morning, my learned senior Kofi Bentil decided not to do law, but politics.
Why is that?
And the reason why he decided not to do law, but politics, is that with all his learning of the law, it would be extremely difficult for him to undermine this judgment. And so conveniently, he chose the path of politics instead of law. But our training is law. The politics is just an addition, regrettably. This morning, my learned senior pontificates very strange legal propositions. One is that an American court can have a say on criminal charges filed in a Ghanaian court yet to be determined. Where from this learning, Bentil?
You don't want me to answer?
No.
You don't want me to answer?
No.
Then no, that question is wrong.
Because
wrong question.
The American court does not have supervisory jurisdiction over the Ghanaian court.
Nobody's saying that. When you ask them to extradite somebody, you brought me in. You ask them to extradite somebody. You effectively ask them to look at what you are doing. Yeah. And they judge it. They said you don't look serious.
Can I proceed?
So don't be me. I have to respond.
As we speak, there is no decision on extradition in respect of Ken Oforiatta. Ken Oforiatta requested for permanent U.S. residency, among others, and he went before an immigration court. It is that immigration court that had given a decision. There's no question whether Ken can be extradited or not. So what are you talking about?
Nobody is saying that.
The request for extradition by the Republic is yet to be decided. So please don't mislead the public.
Right.
We owe it a duty.
He should make his point.
Right. Look, you see, I have seen a wayward American judge who decided to engage in judicial waywardness by pronouncing on criminal charges filed in a Ghanaian court, yet to be decided. Today, as we speak, the United States of America is fighting even the International Criminal Court.
Yes. Yeah.
Even the International Criminal Court, Secretary of State Marco Rubio, is saying that the judges there are lunatics. And you have a Ghanaian lawyer. Please, let us not sell our sovereignty for people.
When you extradited people without proper process.
Now let me deal with the substantive matter. First of all, we are being told that when a charge sheet is defective, that defectiveness should be overlooked. Proceed. My Lord Justice Pega, in his validatory judgment, Osekwejo II and the Republic, said the provision you read relates to Act 30. However, the 1992 Constitution has raised particularity relative to charge sheet to a constitutional pedestal. Article 19, 1D. And for that matter, where particulars are defective, you cannot use evidence to cure that defect. And so if you look, Sedi had two appeals. When prosecution called its 6 witnesses, the prosecution said they have closed their case. A submission of no case was done. One of the issues Sedi raised right from the beginning had to do with the defectiveness of the charge. The High Court judge said, proceed and answer the charges. That submission of no case was appealed against. And if you read the notice of appeal and the grounds in respect of the submission of no case, included the fact that, one of it clearly had to do with the defective charge sheet. So it is in the notice of appeal.
The 2024 one?
Yes. And no, so the first appeal was August 2023. That was when she was called to open her defense. But then they raised that issue. Now, when the judgment was delivered in May 2024, if you look at the notice of appeal filed on the 9th of May 2024, in that notice is the omnibus ground. Which omnibus ground is the fact that the judgment is unreasonable, having regards to the evidence on record. All of us lawyers here seated know that once that omnibus grounds of appeal is raised, the entire proceeding is subject to review. And that is why we say appeal is by way of what? Rehearing. It means that everything that happened at the trial court, the appellate court is put in that position. Obviously, they don't have the benefit of assessing demeanors. Because the trial court is the only one that gets the opportunity to see witnesses and others. The appellate, they are just going to look at just the record without more. Okay. Now, I have heard the former Attorney General, the former persecutor, say that the notice of appeal was not brought to his attention.
Yes.
Yeah, yes. Can you imagine? Clearly, it shows you that the guy was sleeping on the job.
Well, this is the part of the statement. He says, no notice of an appeal filed by Sedinam in 2024 came to the attention of the Office of the Attorney General in my tenure.
Please, hold on. I've read the statement.
And deal with the records too.
Please, I've read the statement.
The records were not also filed.
I'll deal with it. You see, Kofi, you are a lawyer. Don't do this.
Hey, Master.
Senior.
Bring me in.
Yes, you will. But my point is that as lawyers, there's a bigger standard placed on us. With the greatest of respect to you, you can't speak like Anyaba. He's a politician. He is permitted to express any opinion, anyhow. Desirable. But you, a standard is placed on you. You cannot sacrifice that standard on the altar of political expediency. Why do I say so? On the 9th of May 2024, the notice of appeal was filed at the registry of the High Court. Whose permission or duty is it to serve that notice? Sedi? 2, the point had been made that pieces of the records were even missing. Look, I have with me the decision of the Court of Appeal differently constituted. Because the Attorney General brought an application before the Court of Appeal for rectification of the record. Is that not the procedure that the rules permit when you have issues about the records, is to apply for rectification? The Attorney General applied to the Court of Appeal, presided over by Justices Georgina Dacha, Amedahe, and another one, who reviewed, in fact, said these lawyers opposed the application on the grounds that the very document they claimed were missing are documents that the prosecution itself disclosed to them. And so for that matter, you cannot be saying that your own document is missing from the record. Said these lawyers oppose it. The Court of Appeal looked at the two sides and came to the conclusion that regardless of the fact, your claim that the prosecution has it already, our decision is that the records ought to be done again. And those documents submitted to the Attorney General. Are you aware of that? And so what have you decided to do? Bandy misleading information to cheer up your supporters who have lost an election. Sedi is not the reason why you lost your election, a devastating election. Sedi is not the reason. Now, there are substantive matters. First of all, the counts were 78. The defective counts were even less than 10. Mm-hmm. The rest of the charges were evaluated on their merit. You did a shoddy work, poor work. Godfred supervised the poor work.
That's why he doesn't disagrees with you.
And you know why? He never took his work serious.
What do you mean by that?
Yes. And I'll tell you. And you see, sometimes when I listen to Godfred, I say, look.
I beg, the man is not here. Stop.
But the statement he issued, what do you think he was doing? This is an innocent person that he seeks to attack and destroy.
Who is the innocent person he's attacking?
Oh.
The man is AG doing his work. If he's here, he will defend himself. But I am complaining.
So let me make my point. Let me make my point. I've listened to him.
So are you referencing the statement he made?
The statement he made. I'm not permitted. Who issued the statement?
No, you deal with the statement.
No, Kofi, who issued the statement? What is this trying? Imagine if it's found that there was no notice of appeal. Do you know what Godfred would have succeeded in doing? Is to undermine even the judges. Why would you have entertained an appeal when there is no notice of appeal?
Are you referencing this particular document?
See the date, 9th. Where is it? The registry of the High Court. 9th May 2024. Signed, High Court Accra. This is fictitious, shameful. And you think this person should be taken serious? And you see the painful part of this conversation is that, and like I said, this is not one who. In the Atofose matter, the same shoddy work was done by him. What happened? The same High Court judge says the burden was shifted on Atofose. Look, I've always maintained the only work I would do permanent is to be a lawyer. It's to be a lawyer.
Right now, you sell petrol.
That's why I say permanent. This one is not chieftaincy title. I will leave it. You understand? So I have always been cautious in dealing with legal matters, particularly those that borders on the liberty of an individual. The liberty. You have a situation where the justices of the Court of Appeal had the opportunity of evaluating. And look, I am not surprised. Look, when the Court of Appeal acquitted and discharged Atofose, go and look at Godfred's statement he issued immediately. Was to attack the justices of the Court of Appeal. That's him.
Because it didn't go
because it didn't go his way. There's an attorney general who today, a former attorney general who today, the disciplinary committee of the General Legal Council had found a prima facie case of professional misconduct against him.
He says the Republic
when was the last time you saw this happen?
Said the Republic had nothing to do in this 2024 matter in terms of the conduct of that appeal.
Look, let me just go
That's
ahead.
what he references.
The office of the Attorney General does not belong to Godfred Dame. It is an office that continues. The state prosecutor on record, if you read the judgment, the Court of Appeal judgment, you have it.
Yes.
There's a named individual there, Hilda Craig. Mm-hmm. She was part of the people who prosecuted the case before the High Court. She handled the appeal and a different outcome. Unless, of course, my friend here, and listening to Ahiagba has, won't me filed a notice of appeal?
I know that the process underway. I don't know if they're found.
Yes, this was
so the understanding I get from you is that you expect only one outcome from the Court of Appeal, a dismissal of the appeal.
No, not exactly. I didn't say that. I didn't suggest that.
You didn't know why I asked you that question.
Well, I didn't suggest that.
Think through my question.
Think about what Martin said before you answer.
But you see, I asked you this question for an obvious reason.
So that is a blackmail question that you're asking.
It's a trick question.
Yeah, it's a blackmail question.
You see,
What's the point?
You see, the point I am making is that, Alfred, I've heard people who have not even read the judgment pontificate on it. Yeah. This morning, when I listened to my learned senior,
Your learned senior Martin says,
no, you.
Your
I'm coming.
Listen to him
you
too.
would stay calm.
Rehearing was the normal outcome of this.
Kofi, listen to me.
Listen on your philosophy.
Listen. No, what philosophy?
learned
He is
senior,
not
you
even.
listen to him.
My point is that, Kofi, with the greatest of respect to you, you have not exhausted this judgment. You have not. I've listened to you, and you have not. And you have
Tell
not.
me where.
You have not, because if you read this judgment, it will expose your prejudices.
What exactly?
What
are you
I've
talking
read
about?
confirms what I've said.
You see,
But you have not read all.
please, the defective
himself
charges,
hasn't read
the defective charges. For instance, count 45. Conspiracy to commit crime, namely, willfully causing financial loss to the state, contrary to section so and so. Now listen to the particulars. Sedinam Christian Tamaklo Ationo, Daniel Axim, April 2016, in Accra, in the Greater Accra region, agreed to act together with a common purpose to willfully cause financial loss to the state. That's it. Kofi, you read
What's your
criminal
point?
procedure.
Point.
We both did criminal procedure, because without it, you won't be a lawyer. Is that how you put a criminal charge?
Martin is an authority in criminal law. He says the point here, if you read everything,
Martin never said that.
He never said it's an.
Martin,
he is not saying. I am saying.
Please stop.
I am saying he's
Please
an
stop.
authority in that. He says the natural conclusion. I agree with him. That's what I'm saying. So.
Hold on.
You are referring to someone as
He's an authority. Martin is an authority.
Because
they study him in criminal. You bring me in, I'll answer you.
I beg you.
He said rehearing is the normal thing that you should have expected in this case.
Because
You should stay on his case.
if you
and stop calling.
read the counts, a count should be an invitation to offer a defense. So the count must contain an act or omission. Where is it here?
You are wrong.
So please, why am I?
No,
wait,
Mr. Bentil,
For the
I'll-
public's sake.
Why
I'll come to
public
you. We
sake?
just note it.
A
I'll
count
come
is
to
not
you.
an invitation to offer a defense. A count is a statement that the prosecution must
Mr.
prove.
Bentil. Mr. Bentil.
You see, you don't even know what you are talking about. Senior.
Okay, no
So
problem.
if you
So
look,
easy.
Yes.
in the Republic versus Ernest Thompson, Ernest Thompson challenged the charges that were brought against him. The High Court dismissed it. He said the charges were defective. It went to the Court of Appeal. He further appealed to the Supreme Court. I invite you to read my Lord Justice Tanko's reasoning. My Lord Justice Tanko took the view that the charge must contain a certain level of sufficiency to meet a constitutional threshold. The lack of it is not cured by amendment. You strike it out. Now, on appeal, if you strike a charge out, everything found on it will collapse. So it is not the charge sheet that was struck out, but specific counts. Those counts that meet the constitutional threshold were allowed to stand. Now, what the judges did, what the judges then did, was now go into the merit, the specific merit of those counts. My senior, what's the name, Martin, raised a very interesting point. Which interesting point had to do with the specifics, the counts. He's done an extremely good job on it. If you pick, for instance, the one bordering on causing financial loss to the states, about the buses, okay? The buses that were
But for GPRTU.
were bought, 350 buses.
Somebody commits a crime.
Your challenge was that
Somebody pays.
he had committed causing financial loss to the state. In the charge of causing financial loss, the fundamental thing that you have to establish is that, in fact, the person authorized payment. Because without it, the charge will not succeed. It is not a charge that is left hanging. The charge must found factual basis So the justice of the Court of Appeal reasoned otherwise and said, your charge is that ABCD was not done, for which reason you are charging the appellant. By your own prosecution, and guess who the first prosecution witness was? The current MP for Shǎmeful, Sticker. He was the first prosecution witness. Now, guess what happened under cross-examination of Mr.
Sedinam.
Sedinam. I always still call him Sticker.
Dr. Sedinam.
Exactly. Under cross-examination, lawyers for Sedi asked him a very specific question. And also the Director of Finance was brought in as the fifth prosecution witness, the Director of Finance of Maslock. So the question was put to him. I'm trying to retrieve that particular portion. Because you see, Alfred, I think that people need to see what is on record. When you see what is on record, if you can still, in the face of those evidence or pieces of evidence on record, still come to a different conclusion, then yours is just not a question of law, but you are looking at something else. Alfred, permit me to read it.
On where exactly? So that, while we flip through.
No, I'm going to the records, the records of proceedings. Sticker. Okay. PW1. You will see his testimony at page 80 of volume 3 of the record of appeal. Page 80 of volume 3 of the records. Question. You also know from your records that the contract for the acquisition of the vehicles had been signed by your predecessor, but not a single cedi had been paid by Maslock. Is that correct? Answer. Yes, my lady. That's Sticker.
That no payments were made.
Yes. Now, at page 294 of volume 3 of the records of proceedings, PW5, the Director of Finance of Maslock, under cross-examination. Question. Your CEO has testified in this court that they renegotiated the entire contract price. Is that the case? Answer. Unfortunately, I cannot speak on my CEO's testimony. Question. I'm asking you personally. Maslock says that the contract price was renegotiated. Is that the case? Answer. From what the person gave to me, yes. This is prosecution witnesses. Now again, at page 297, 294 of volume 3 of the records, question, the same Director of Finance. This renegotiated contract was done for how many years after A1 had left office? Answer, I have no idea. Prosecution witnesses. Question, but you will be able to tell the court when the payment was made. Is that correct? Answer, yes. Question, when was it made? Answer, 2018. A1 exited office first week in January 2017. Is that correct? Answer, that is correct.
A1 talking about Sedinam.
Yes. And you people sit here and say that she should be put in prison to make you happy.
So,
what kind of democracy are we running? Now, even shocking.
On what basis? And what do you?
I'm doing merit. I'll yield to them. I invite you, go to the judgment. Page 85. Please, are you there?
Page 85.
85 of the judgment. And so if anybody tells you that this case was lost on technicalities, the person doesn't even know what he's talking about. Ignorance. 85. Again, PW5, Director of Finance of Maslock, who Godfred, in his wisdom, brought to the court as his prosecution witness. When he looked at all the people in this world, he brought PW5 to come and prove his case for him. Competent dummy. Let's see. Question. You tendered Exhibit AD, AC, AB, which relates to payment of end of leave and ex gratia to A1 and her former deputy. Is that correct? Answer. That is correct. Question. The payments were processed by your office. Is that correct? Answer. Very correct. Question. The processing was based on documents relating to the appointments.
Reading court documents.
Relating to the appointment of A1 and her former deputy. Is that correct? Answer. Very correct. In processing for this payment, did you notice anything untoward? Question. No, I did not notice anything untoward. Question. You put your signature under this payment because you did not find anything wrong with this payment. Is that correct? Answer. I authorized those payments because I did not find anything wrong with it.
And this is who speaking?
PW5. Godfred Dami's witness against Sedi. So if you read this judgment, in the face of this, is that the appellate court, even the Supreme Court, going to vary these records when they are bound by it.
I see.
And so, you see, I have listened to people, I've listened to my two brothers here today, and I'm like asking myself, what kind of justice system do we want? The justice system where my brother Richard Ahiagba can even speculate and conjecture and say that it meets a political convenient statement to put somebody in, even if there is no evidence.
There was a question directed
Richard,
at Martin.
what democracy do you think we'll be building?
I see. No. Mr. Agba, no, you want to come? What was it?
But you know, yes. I didn't have my time to
you say you
make
want
any
to hear him. So that
yes, so now I'm not PENDREAM TV. Now, so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.